Don't forget, you can reach the latest episode of Potomac Watch anytime. Just ask your smart speaker, play the Opinion Potomac Watch podcast.
From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Welcome back. The other place that the Supreme Court's recent ruling in the racial preferences case involving Harvard is having an effect is in potentially government contracting. And we raised this in the podcast last week as a question, and it didn't take long to get an answer. A U.S. District Court judge in Tennessee, the Eastern District of Tennessee, has now enjoined the Small Business Administration from using a rebuttable presumption of social disadvantage in its contracting program. And just to unpack that a little bit, the Small Business Administration has an 8A business development program. The website says that the federal government's goal is to award at least 5% of all federal contracting dollars to small disadvantaged businesses each year. And as the judge explains in his ruling, the way that the SBA rules are set up, certain minority groups that are applying to the 8A program are presumed to be socially disadvantaged. And so they don't have to submit any evidence of that individually. They're just kind of waived into the program. And Alicia, this judge is now saying and citing the Students for Fair Admissions case several times that does not meet the Supreme Court's test for this sort of racial analysis in government programs.
Right. So Students for Fair Admissions, again, it ostensibly only applied to the college admissions process. The ruling was under the Equal Protection Clause, but it was essentially when the Supreme Court rules something that violates the Equal Protection Clause, it's presumed to also violate Title VI, which is just any programs receiving federal funds. It also can be extended, the same interpretations and legal arguments can be extended to government contracting, essentially these set-asides that federal government, the Small Business Administration, but also a lot of local governments make that essentially say 10 or 15% of contracts or grants must go to minority-owned or socially disadvantaged. If we recall, there was a loan forgiveness program that Democrats wrote into one of their COVID relief laws that would provide loan forgiveness for disadvantaged farmers, which was the USDA interpreted to mean minorities, Blacks, Hispanics, and such. And that was ruled illegal by a number of federal courts on this very premise that it violated equal protection. Now, I think you're going to see more and more challenges to these kinds of programs at the government level, but also, interestingly, I think you're going to see a lot of them, going back to what we were discussing earlier, even by private companies, which are bound by Section 1981 of the Civil Rights Act of 1866, which actually prohibits discrimination on the basis of race and ethnicity in terms of companies or private companies making and enforcing contracts. Now, the interesting thing here is a lot of these companies, as we were discussing earlier, have actually said, maybe you could call them aspirational goals, but I think they're actually more akin to quotas of that they're going to provide such and such 5 or 10% of their contracts to Blacks or Hispanics. I actually, interestingly, wrote an editorial maybe a month or two ago about McDonald's was getting sued by this media mogul, Byron Allen, over its aspirational goal. McDonald's had pledged to provide Black media-owned producers or content companies 5% of essentially its ad revenue. And Byron Allen claimed that this was insufficient, that the McDonald's should actually be giving more to the Black content producers or Black firms. And this is now going to trial. But I think there's actually a very strong argument that the McDonald's pledge violates Section 1981 of the Civil Rights Act, which is the very thing that Byron Allen claims that the company is violating. So again, going back to your question, I think there's going to be challenges both to government contracting and set-asides and both private company set-asides.
That kind of broad reading of the Students for Fair Admissions case is, I think, why it was so important that the Supreme Court drew that bright line. And I would point to, again, a couple lines from this judge's ruling on the Small Business Administration program. He says, the facts in Students for Fair Admission concerned college admissions programs, but its reasoning is not limited to just those programs. One other place he cites it is in saying that the Supreme Court recently reaffirmed that racially conscious government programs must have a logical endpoint. And then he also pulls out a section of the opinion saying that specified minority groups include entire populations that cannot be neatly categorized according to the SBA's definition for those minority groups. And that, I think, is potentially another long tail, Colin, from this Harvard case. And a line in the majority opinion by Chief Justice John Roberts that I think deserves more attention deals with that fact on how these groupings were actually created. And Chief Justice says other racial categories, such as Hispanic, are arbitrary or undefined. And I think that is a notable statement from the Chief Justice talking about one of these groups. I mean, Hispanic has not historically been taken to be a racial group because Hispanics can be black or they can be white. There are Asian Hispanics in the United States, millions of them, I believe, if I'm remembering the data from the Pew Research Center correctly. And so it suggests that there's going to be some serious scrutiny that is put on the use of these categories as anything other than statistics that are being collected by the Census Bureau. If they're going to be used to decide who gets certain benefits, for example, then the government has to really show that the classification, the category, is fit to the purpose to which it's being put.
That's right. I think the more obviously that we can get away from the box ticking of the categories, the better. We were talking earlier about some of these more race neutral ways to achieve some of the same goals. It reminded me as we were talking about it that Texas many years ago now used a top 10% law where their goal was to take the top 10% of every high school graduating class and accept those into the state public universities. Something along those lines is something that corporations could probably more reasonably use. So let's take the top 10% of every college graduating class or spread things a little bit that way. And all of it is obviously going to get sorted out in many different forums in future years. But there's one other point that I wanted to make here, Kyle. It's sort of a fundamental thing, but to go off on the judge's point about needing a logical end point to these discussions is that if we want to stop arguing about this issue, we really have to have a much more comprehensive discussion about public education that begins in the early grades, because this is a bit of a rant of mine, but the way that public education is currently operated with unions that protect the interests of their members over the future prospect of their students is overwhelmingly harming children who are Black and Hispanic, and most direly harming those same racial categories who are economically disadvantaged. So the inner city schools make it impossible for the children to succeed because they're being raised in this toxic environment. And that's the purest form of systemic racism that exists. So we're battling about this affirmative action at the college and corporate level, but we really need to be battling about it at a much earlier stage so that people actually have a chance to succeed.
Alicia, it's hard to predict the future, obviously, but it does suggest that this Students for Fair Admissions case is going to be seen potentially as one of those landmark cases that signaled not only a victory or a loss for the parties that were standing before the Supreme Court making their argument, but a sea change in how the Supreme Court sees these kinds of issues, with those interpretive changes kind of percolating down through the lower courts. And granted, we don't know if this 6-3 conservative Supreme Court will last for another 5 years or 10 years. It's not hard to imagine some turnover in those justices, depending on what happens in the 2024 election. But it does seem to me that potentially Students for Fair Admissions is a case that law students will be reading about for a long time.
I think that's right. I think it is going to be a landmark case because of the opinion. It was so clear in contrast to some of its previous opinions actually on the issues, which really muddled the issue. And I'd say the same thing with the irony of here is that the chief, in a separate decision this term with regards to an Alabama redistricting plan, essentially sanctioned racial, maybe it's not racial preferences, but basically divvying up the districts based on race and saying that Alabama needed to have 2 majority Black districts because that was essentially reflecting its population. And here in the Harvard case, he kind of ruled the opposite. So it'll be interesting to see whether also in the coming terms, whether we get any more clarity on what's required under the Voting Rights Act, which has been a similar muddle to its previous muddle on college admissions and race.
Thank you, Alicia and Colin. Thank you all for listening. You can email us at pwpodcast@wsj.com. If you like the show, please hit that subscribe button, and we'll be back tomorrow with another edition of Potomac Watch.